Kathryn, perhaps you could tell me a little bit about what the law's about?
So on June 9th in California, a new law was implemented called the California End-of-Life Options Act. The purpose of that act is to empower dying patients who may find themselves trapped in a dying process that is unbearable to have an additional end-of-life choice where they can turn to their physician and ask for a prescription for medication that they would ingest in order to achieve a peaceful death. And that practice is called aid in dying. The patient must self-administer the medication. If a patient has a physical disability which makes it impossible to self-administer, they would not be eligible. Fortunately, that's very rare, and for the most part, a patient, even a patient with ALS who has a vestigial swallowing ability could, for example, self-administer through sipping a straw, and that would constitute self-administration. It is the physician who primarily interfaces with the patient and has the discussion about the patient's wish. Obviously, when that happens, all kinds of discussion should happen around, well, what are other options? But the physician then would explain the process to the patient. The patient must make multiple requests, oral and written. Those must be witnessed. They must be documented in the patient's medical chart. The physician must establish that the patient is mentally competent and able to make an informed decision. The physician must establish that the patient, in fact, has life expectancy of 6 months or less. The attending physician must hold the opinion that the patient has competency. There must be a consulting physician who agrees. If either of those two physicians has any question, then a referral to a mental health specialist would be made. Then the physician would feel safe in writing a prescription for medication which the patient could self-administer to achieve a peaceful death. The physicians who participate in aid in dying are required to submit reports to the state documenting that all of the procedure was followed. And then the data of each individual patient is collected by the state and reported annually, much like it is in Oregon and Washington.